environment. Mahalo for your time and attention.
Good morning. My name is Anne Marie Puglisi, manager for the Equal Employment Opportunity Office for the executive branch of the state. We provide resources to all of the departments in the executive branch, other than the Department of Education and the Board of Regent appointees at the University of Hawaii. So we provide resources on EEO matters to the personnel office, offices of the different departments. We are here as a resource for employees, and we also provide training, and that's what we're doing today. A little background about me: I'm an attorney by trade, but I'm not practicing law in this position, so I'm a recovering attorney. But my background, when I was practicing law, was in the area of employment and labor law. And most recently, I was at the Attorney General's office in the Employment Law Division. So we're here today we're training on the Discrimination Harassment-Free Workplace Policy. Everybody should have received a copy of this policy from their department. If you didn't, you need to make sure and get one. Also, there are some training materials that should have been provided to you by your department. So if you don't have those, you can get them when you return to your department. Just ask your supervisor for a copy. My contact information is on the front and the back screen, or the front and the back page of the materials. Feel free to call or email me if you have any questions, and if you have some that you think of after the training, or if you aren't able to ask a question today. So what we're going to go over today is what unlawful discrimination and harassment is. We're going to talk about the legally protected classes. Okay? There are legally protected classes defined by federal and state law. We're going to talk about what behavior is unlawful in the workplace and what behavior violates the Discrimination Harassment-Free Workplace Policy. For ease of reference, I am going to refer to the Discrimination Harassment-Free Workplace Policy as the policy. So when I refer to the policy, that's what I mean. We're going to talk about what you should do as employees if you feel like you've been subjected to discrimination or harassment. We're going to talk about retaliation and what it is, what you should do if you feel like you're subjected to it. And then we're going to talk about your responsibilities as employees under the policy. So in Section 1 of your policy, we have incorporated the policy of the state, and that is to provide a work environment free of any form of discrimination, harassment, or retaliation that's based on protected classes. All right? The policy is 601.001. You can find it on the DHERD website, the Department of Human Resources Development website. If you go to the home page, there's a tab for policies and procedures. If you click on that tab, all of the statewide policies will be listed numerically. You can find this policy there. Or on the home page, there's also a tab or a link for EEO. And if you click on that, there's a link that'll take you right to this policy. So why are we doing this? Why are we having all of our employees go through training? Why do we now have a statewide policy? I know every department had their own discrimination harassment free type policy. Now we have a statewide policy. And we're doing this because we want to maintain a productive work environment for our employees. Employees have the right to come to work and be free of discrimination and harassment based on protected classes. Also, it's the law. Both federal and state law prohibit discrimination and harassment based on protected classes in the workplace. So if an employer allows discrimination or harassment to occur in the workplace, the employer can get in trouble. Okay? They can be found liable. They may have to pay damages. And if an employee engages in conduct that's discriminatory or harassing, they can get in trouble too, okay? And that means they could be named personally as a defendant in a lawsuit. They may have to pay damages, punitive damages, compensatory damages, intentional infliction of emotional distress damages, and they may also have to pay their own attorney's fees, okay? Because the U.S. Supreme Court has held that discrimination and harassment is not in the course and scope of a person's employment. It's not part of your job. Okay? And the state does not have to provide a defense to employees who are acting outside of their course and scope of employment. Okay? That means the state does not necessarily have to provide an attorney if somebody is sued in a lawsuit. Also, we want to comply with the state's policy. Okay? Conduct under the policy does not have to rise to the level of unlawful discrimination or harassment to violate the policy. And if an employee engages in conduct that violates the policy, they can be disciplined up to and including termination. That's in Section 1 of your policy. So what is unlawful discrimination? It's defined in Section 5A1 of your policy. And it's basically any employment decision, any employment action that is taken because of a person's protected class. Okay? So employment actions include decisions made during recruitment, hiring, assignment of work, training, compensation, benefits, evaluations, promotions, demotions, discipline, and termination. Okay? So any employment action that's based on a person's protected class. And then there's a form of discrimination called disparate impact. This is when an employer has a policy that appears to apply to everybody equally, applies to everybody the same way. The problem is sometimes policies impact individuals in a certain protected class. An example of this that's been litigated quite a bit is height and weight requirements. Sometimes employers will require that applicants meet a certain height or weight to be able to take a job. Okay, this is common with firefighters, police officers, those type of positions. And the lawsuits revolved around the fact that this impacted women as a protected class, because women typically aren't as tall and don't weigh as much as men. But today we're going to talk about employment actions because that's what affects us on a day-to-day basis in the workplace. So what are the protected classes that I keep referring to? Okay, they're listed in Section 3 of your policy, and they've been defined by federal and state law. Okay? Race is a protected class. That is a person's ethnicity: Hispanic, African American, Asian, Native American, Native Hawaiian, Alaskan Native, Caucasian. Color is the color of a person's skin. Religion includes all aspects of religious observance and practice. Sex, okay, that's gender. That includes male and female. It also includes gender identity or expression. That is when a person is born of one sex, but they identify with the opposite sex, or they express themselves as the opposite sex, or they physically transition to the opposite sex. Okay? That is a protected class. Sexual orientation is also protected: heterosexuality, bisexuality, homosexuality. National origin is the country from which a person comes or from which their family comes. That is a protected class. Age is protected. Under federal law, employees over the age of 40 are protected, so employment decisions can't be based on the fact that an employee is over the age of 40. But in Hawaii, they have broadened that. Okay? Under Hawaii law, it's broader. It protects employees of all ages. So in Hawaii, employment decisions can't be based on an employee's age, and it doesn't matter what the age is. Physical or mental disability is a protected class. Physical or mental disabilities have been defined by the Americans with Disabilities Act, which is a federal law. And it's defined as any physical or mental impairment that substantially limits a major life activity. This definition is very broad. It's not your traditional idea of a disability. It includes most serious medical conditions. Okay? Very broad definition. Genetic information is protected. Okay? Genetic information is becoming more and more common. Genetic testing is more and more common, more and more affordable. People want to know if they're genetically predisposed to certain types of diseases like cancer. Where it affects the employment arena is with medical history. Okay? So if an employee has a family history of cancer or mental illness or some condition that is genetically passed, employment decisions can't be based on that. So an employer can't say, oh, this employee's parent died of cancer, we're afraid that they're going to get cancer and it's going to affect the work site because they're going to be absent a lot, things like that. Cannot base decisions on that. National Guard absence is protected, and so is absences for service in any of the armed forces. Okay? So any absence that is related to service in the armed forces, including National Guard or reserves, is protected. Okay, so employment decisions can't be based on that. Employees can't be terminated because of absences if those absences are due to service in the armed forces. Veteran status is also protected. So if an employee has very strong political opinions that might be in opposition to positions the U.S. military is taking, they cannot take it out on a coworker or an employee in their work site. That is a veteran. Okay? They cannot make employment decisions because a person is a veteran. Citizenship is protected. Okay? So employment decisions can be based on the fact that somebody is or is not a U.S. citizen. All right? Now, it does say, except as permissible by applicable laws, there are some exceptions to this rule, and it's usually in federal sector, high security clearance positions where an employer is required to make sure that an employee is a U.S. citizen. Otherwise, employment decisions can't be based on the fact that somebody is or is not a U.S. citizen. The condition of pregnancy is protected. So employment decisions can't be based on the fact that a person is pregnant or may become pregnant. The act of breastfeeding or expressing milk is protected. Okay? Breastfeeding or expressing milk in the workplace, protected. No employment decisions because a person is breastfeeding or expressing milk in the workplace. Ancestry is protected. That's very similar to national origin. That is a person's lineage, their heritage, where they come from, where their family comes from. Marital status is protected. Employment decisions can be based on the fact that somebody is married or is not married. Right? This includes civil union status, and as of December 2nd, it includes marriages between individuals of the same sex. Arrest and court records are protected. Employment decisions can't be based on the fact that an employee has an arrest or court record. Okay? Arrest records are not convictions. They cannot be considered in making employment decisions, except under very limited circumstances that are defined by statute. And just know that DHERD or your personnel office does appropriate background checks when somebody applies for a job and before they are placed in the job. Okay, so if the arrest and court record needs to be checked, it will be done by DHERD or by your personnel office. So if you have concerns, you hear through the grapevine or your coworker tells you that they were arrested over the weekend and you're concerned it's going to affect the workplace, take it to your personnel office. Okay, they will handle it appropriately. Right? Don't take it upon yourselves to conduct your own background checks on your coworkers. Okay? Take it to the personnel office. Now, convictions, a little different. Convictions can be considered going back 10 years, and they can be considered if they rationally relate to the position that a person is going to be holding. Okay? So if you have a position that, where money is going to be handled, and a person has a conviction of bank robbery, okay, that person could be excluded from a job handling money. All right, credit history is also protected, so employment decisions can't be based on a person's credit history, except when credit history rationally relates to the job they're going to be performing. So again, if somebody has a job or is applying for a job that handles money, then it would be appropriate to check their credit history. But again, that would be done by DHERD or your personnel office. So if you have concerns about a coworker's credit history, you're afraid it's going to affect their work or the department, take it to your personnel office. Income assignment for child support is protected. Okay? This means employment decisions can't be based on the fact that an employee's wages are garnished to pay child support. And then the last protected class is domestic or sexual violence victim status. So if an employee is a victim of domestic or sexual violence, or if they have a dependent who has been a victim of domestic or sexual violence, employment decisions can't be based on that. Typically, this will come into play when an employee is a victim. They will be absent from work for reasons relating to their status as a victim, and they can't be terminated because of absences that relate to their status. All right, so we've talked about unlawful discrimination, employment actions that are based on a protected class. So employment actions based on one of those protected classes we just went over. That's unlawful discrimination. Now we're going to talk about unlawful harassment, which is a form of unlawful discrimination, okay? It is a form of discrimination because it is also conduct that's based on protected classes, all right? And I'm going to warn you right now, it was defined by attorneys, so it is somewhat complicated, okay? They do never make anything easy for us, can they? It's defined in Section 3 of your policy, and it's defined as unwelcome behavior that's based on a person's protected class. So it's based on one of those protected classes we just talked about. Sufficiently severe or pervasive, and it has the purpose or effect of unreasonably interfering with a person's work performance or creating an intimidating, hostile, or offensive work environment. All right, just to make it a little more complicated, we look at it from two different perspectives. We look at it from the victim's eyes. Did the victim find the conduct offensive? Okay, was it subjectively offensive? And then we look at it through a reasonable person's eyes. A reasonable person, somebody in the victim's position and of the same sex who's reasonable, okay? Would that reasonable person also agree that the conduct was offensive? Was it objectively offensive? Okay, this balances out situations where we have a victim who's very, very sensitive, extremely sensitive, and they find everything offensive. Okay, that's why you look at it through a reasonable person's eyes as well, to say, hey, would a reasonable person also find the conduct offensive? Okay, so to help you understand this definition, this complicated definition, we're going to go through some scenarios, and hopefully it will help you understand unlawful harassment discrimination. Randy frequently tells derogatory racial jokes about Filipinos during team meetings. Randy's coworker, Maria, who is a Filipina, is very offended by his jokes. Is Randy's conduct unwelcome? What do you think? Yeah, it's unwelcome. Maria is offended by his jokes. Okay. Is Randy's conduct pervasive? And what we mean by the word pervasive is conduct that's happening frequently, it's happening often, a lot, and it's happening in such a way that you can't get away from it. Okay, so in this scenario, Maria is going to team meetings. Typically, employees are required to go to team meetings. So she has to go to the team meetings. She has to listen to Randy's jokes. Okay, they're happening frequently. So Randy's conduct is pervasive. So is Randy's conduct unlawful harassment or discrimination? Okay, it's unwelcome. It's based on a protected class. He's making racially derogatory jokes. Okay, based on race, national origin. It's pervasive. Maria finds the jokes offensive. A reasonable person in Maria's shoes would probably agree that the jokes are offensive. All right, so Randy's conduct in this scenario is unlawful harassment or discrimination. So does Randy's conduct violate the policy? It does. Okay. Conduct that rises to the level of unlawful conduct will definitely violate the policy. It's always going to violate the policy. What if Randy didn't intend to offend anybody? He was just trying to be funny. Does that matter? No, it doesn't matter. We look at it through the victim's eyes. We don't look at it through Randy's eyes. Okay, so it doesn't matter what Randy thought or intended. It only matters what the victim perceived. So in this case, it only matters what Maria perceived, and she found the jokes offensive. What if Randy was also Filipino? He is just telling jokes about his own race, his own national origin. What's wrong with that? Well, courts have found that employees of the same ethnicity can create hostile work environments. Right? In one case, a supervisor subjected his employee to a 15-minute tirade that included racially derogatory comments, including the N-word. Both the supervisor and the subordinate, the employee, were African American. Okay? The court didn't care. They said that the supervisor created a hostile work environment for that employee. Okay? Now, what if Maria was not Filipina? Why should she care? It's not her race. It's not her national origin. Well, it doesn't matter. Okay? If Maria found the jokes offensive, if a reasonable person would agree that they were offensive, the jokes are inappropriate in the workplace, and they can create a hostile work environment for other employees. What if Randy, instead of telling the jokes at the team meetings, was emailing them or texting them to Maria? Okay, would that make a difference? Nope, would not. Okay, so if Randy was emailing the jokes from his work computer to Maria's work computer, he could be creating a hostile work environment for Maria. Okay, but if Randy was using his personal cell phone or his personal device to email the jokes to Maria, to her personal cell phone or personal device, he could also be creating a hostile work environment for Maria. And that goes for social media. Okay, so if an employee is using social media to communicate to coworkers, and that communication includes derogatory content based on a protected class, so racially derogatory jokes or sexually explicit type content, okay, the employee could be creating a hostile work environment for the coworker. There's a lawsuit pending right now against the state brought by an employee who sued the state and a coworker, alleging the coworker was sexting her through Facebook and through text messages. Okay, sexting, sending photos of body parts. I am sure in that lawsuit, the attorneys on both sides are disputing whether the conduct, whether the emailing of these photos was occurring during working hours, whether it was work-related. Okay? But the coworker is a defendant in the lawsuit, named personally. He may have to pay damages. He may be found liable. He may have to get his own attorney and pay for it himself. And that is not a position any of us want to find ourselves in. So be aware that social media can be a big problem. It can create a hostile work environment. It can get you in trouble. All right? Another scenario. Joey loves to tell funny stories and keep the spirit of good cheer alive in the workplace. One morning, he spies Jessica looking a little tired and depressed. To cheer her up, he tells her a silly story with a sexually explicit line. Jessica looks offended. Joey asks Jessica what's wrong, and she tells him that she found his joke offensive. Joey apologizes, and he doesn't tell any more jokes with sexual references. So, is Joey's conduct unwelcome? Yeah. Okay. Jessica told him it was. Is Joey's conduct severe or pervasive? Okay. He said a joke. It's not severe. Is it pervasive? Is it happening all the time? No. He stopped. Jessica told him she didn't like it, and he never did it again. So his conduct is not pervasive. All right? So it's unwelcome. It's based on a protected class. It's based on gender. But it's not severe or pervasive. So Joey's conduct doesn't rise to the level of unlawful harassment or discrimination. But Joey's conduct violates the state's policy. Okay? Telling jokes in the workplace with sexually explicit lines is inappropriate. It violates the policy. All right, now let's just say instead of telling a joke, Joey grabbed Jessica's breast because he thought it might cheer her up. I don't know. All right, would that be unwelcome? Yes, okay, we would all agree that kind of touching is unwelcome. Is it pervasive? Okay. Happened once, didn't happen again, not pervasive. But is it severe? Okay, it's severe. The Hawaii Supreme Court has held that this type of touching in certain parts of the body, is severe in and of itself, okay? It's unlawful harassment. In that case, an employee pinched the bottom of a coworker, okay? That was unlawful harassment. It was severe when it happened one time, even before the employer had an opportunity to stop it, okay? So Joey's conduct, grabbing Jessica's breast, would be unlawful harassment or discrimination, and it definitely violates the state's policy. All right, let's look at creating an intimidating, hostile, or offensive work environment. Nikki has a 9x12 calendar of nude males on her cubicle wall visible to anyone passing by. Her coworkers complain because it bothers them. Is the presence of Nikki's calendar welcome? No. Nope. Her coworkers complain. Not welcome. Okay. Is it severe or pervasive? It's pervasive, right? It's pinned up on her cubicle wall, and anybody walking by has to look at it unless they shut their eyes. So it's pervasive. Now, severe, I don't know how the courts would come down on nudity in the workplace. They may find that, like touching certain parts of the body, it's severe. Okay, we don't know that. I don't know the answer to that, but we do know in this case it is pervasive. So Nikki's calendar is unwelcome. It's based on a protected class. It's based on gender. Okay, and it's pervasive. So does it create an intimidating, hostile, or offensive work environment for her coworkers? Yeah, it does. Okay. So just so you know, calendars, photographs, or images of nudity in the workplace are never going to be appropriate. Never. Okay. And that includes bikini-clad women, shirtless firemen. All right. And that can include artwork. There are plenty of really well-known artists who like to depict nude bodies. And I'm not saying there's anything wrong with that, but if you have it, keep it at home. Don't bring it to the workplace because it's not going to be appropriate at work. All right, let's look at unreasonably interfering with work performance. While at work, Liza frequently makes personal phone calls to her friends. Her conversations are loud and generously sprinkled with racial epithets. Her coworkers in nearby cubicles cannot help but overhear her conversations. Okay, are Liza's personal phone calls welcome? No. Okay, now her coworkers have not complained, all right, but I'm sure they will eventually, or if you ask them, they would tell you they don't find the phone calls welcome, okay? Are Liza's personal phone calls severe or pervasive? Okay, they're not severe, okay, they're those type of derogatory comments aren't severe in and of themselves, but her phone calls are pervasive. They're happening frequently, and they're happening in such a way that her coworkers have to hear them. So they're pervasive. Okay, so unwelcome conduct, that's based on a protected class, it's based on race, and it's pervasive. All right, so are Liza's phone calls unreasonably interfering with her coworkers' work performance? What do you think? Yeah? Okay. Just think about it. If you had a coworker who was making personal phone calls, you had to overhear them, couldn't help but hear them, that would make it hard to get your work done. But if those personal phone calls included racially derogatory comments, okay, sexually explicit content, if Liza was talking about her sex life in detail, and you had to listen to that, that would unreasonably interfere with your ability to get your work done. Okay, so Liza's phone calls are unreasonably interfering with her work performance. They are unlawful harassment or discrimination. Okay, so hopefully that helps you understand this concept a little better. We're going to go through some scenarios now dealing with the different protected classes. We're not going to go through every protected class because I know you want to go back to work today. All right, so first we're going to start with the protected class of sex or gender. All right, that includes male and female. It includes gender identity or expression. So that is when a person is born one sex, but they identify with the opposite sex. So a person is born male, but they identify as a female. They express themselves as a female, so they dress as a woman, or they physically transition to the female sex. Or a person is born female, but that person identifies as a male. They dress as a man, express themselves as a male, or physically transition to the male sex. That's also referred to as transgender. Okay, so you may hear the term transgender, gender identity or expression, same thing. All right. Then there's sexual orientation, part of this protected class. That is heterosexuality, homosexuality, or bisexuality. And then there are times when individuals of the same sex can create hostile work environments regardless of their sexual orientation. All right, Tony persists in asking his coworker Nalani out to dinner, even though she turns him down each and every time he asks her on a date. She has told him several times to stop asking. True or false? Tony's behavior is not at risk for sexual harassment because sexual harassment may only occur between a male boss and a female subordinate. All right. I was going to ask who thinks it's true, but I hear everybody thinks it's false. Okay, and you are right. It's false. I'm really glad that you know that, okay, because we know sexual harassment can occur between coworkers, right? Can occur between employees who work together in the work site. It can occur between a female boss and a male subordinate. It can also occur between employees of the same sex. All right. There is a U.S. Supreme Court case where they dealt with facts that arose on an oil rig in the Gulf of Mexico, all male employees. Two of the male employees were making sexual comments to a third male employee, threatening the third male employee in sexual ways, and actually assaulted him in a sexual way. Okay. The two female coworkers or employees were not sexually attracted to the third male employee. Right? But the third male employee sued for sexual harassment and went all the way up to the United States Supreme Court. Okay. The U.S. Supreme Court found that it was sexual harassment. Okay. They didn't care that the two male employees were not sexually attracted to the third employee. Okay. The conduct was sexual in nature. It was based on sex. So they found it was sexual harassment. Another case, a female supervisor subjected her female employee to comments about her sex life in front of the female employee's male coworkers. Okay? Comments about her sex life, a lot of detailed questions about her sex life. She would ask her what color her underwear was, whether it matched, and at one point actually pulled her shirt out to see. Okay? The female employee sued for sexual harassment. The female supervisor was not sexually attracted to the female employee, but the court found it was sexual harassment because the conduct was sexual in nature. Okay. Just so you know, the supervisor was named personally in that lawsuit as a defendant and was found liable and got to pay damages out of her own pocket. Probably got to pay her own attorney's fees all the way up through the Court of Appeals, which can cost hundreds of thousands of dollars. All right. Robert is in the process of transitioning from male to female. He has requested to be called Roberta and wears women's clothes to work. Her coworkers continue to call her Robert, make fun of her, and make derogatory comments about the transition. True or false? Roberta's coworkers haven't done anything wrong because it's normal to feel uncomfortable around someone who is transitioning. Okay. I hear a consensus of false, and you are right. Okay? It is false. When an employee identifies with the opposite sex, okay, expresses themselves as the opposite sex, or physically transitions to the opposite sex, if they want to be called Roberta, we call them Roberta. Okay? If they want to be called she, we refer to them as she. It doesn't matter if we feel uncomfortable with it. This is a legally protected class. Okay? In Roberta's case, her coworkers were creating a hostile work environment. They were making fun of her, making derogatory comments about the transition. Most of those were based on her protected class. All right, religion. Religion includes all aspects of religious observance and practice. Okay, so that includes all the established religions, okay, the established denominations you've heard of, Catholic, Judaism, Baptist, Methodist, Mormons, so all the established religions. It also includes sincerely held beliefs. Sincerely held beliefs may be beliefs that somebody holds, but they are not necessarily part of an established religion. Okay, the courts look at it the same way. And employers are required to provide reasonable accommodations to employees for their religious observances, okay, including sincerely held beliefs. So what that usually entails is scheduling issues. So let's say we have an employee, and the employee's holy day is Saturday. They want Saturdays off so they can observe their holy day. The employer needs to allow them to have Saturdays off. But we work for the state, and we know that there are a lot of collective bargaining agreements in place. And the collective bargaining agreements typically dictate how scheduling is to be assigned. All right? An employer does not have to violate a collective bargaining agreement to accommodate somebody's religious observance. That would not be a reasonable accommodation. But if that employee who wanted Saturdays off could find a coworker who would be willing to switch shifts with him, okay, and it doesn't violate the collective bargaining agreement, then the employer should allow it to happen. Other times, employees have religious services they want to attend. Could be on an annual basis, several times a year, or it could be on a regular basis. The employer needs to allow them that time off to attend those religious services. And if it's happening on a regular basis, let's just say an employee wants to leave early every Wednesday to go to a religious service, the employer needs to allow them the time off and, if possible, work with them to come up with some kind of flex schedule that would allow them to get their 8 hours in. Because the employee still does have to work 8 hours to get paid the 8 hours. Another area where this comes into play is with dress codes. So let's say we have an employee who has a head covering that they wear in observance of their religion. And it has a lot of fabric. And this employee wants to work in an area with machinery, a lot of moving parts. Okay, so all that fabric would create a safety hazard working in the area of machinery with moving parts. The employer would not be required to accommodate that religious observance because it creates a safety hazard. They do not have to put employees in danger to accommodate religious observances. But if it was an office setting and this employee wanted to wear his or her head covering in the workplace and there was a rule that said no hats in the workplace, the employer would be required to modify that rule or make an exception to it to allow the employee to wear the head covering to work. All right, inappropriate behavior that is based on religion. Examples, okay, include antagonizing or ridiculing somebody because of their religious beliefs, or antagonizing or ridiculing someone because they don't believe the same way you do. Okay? Preaching or proselytizing to an employee who does not find it welcome. All right, so employees have the right to their religious beliefs. They do, okay? And they can express those religious beliefs, but there is a line that can be crossed into the appropriate conduct area, okay? So when somebody expresses their religious beliefs and that becomes critical towards other employees, argumentative, or derogatory, we've crossed the line into inappropriate conduct. Or if an employee expresses their religious beliefs and then immediately tries to convert the coworker they're talking to, okay, that gets us into inappropriate conduct in the workplace, all right? This goes for people who may not have religious beliefs of any kind, but they are derogatory towards another employee who does, okay, that's still also going to be inappropriate. All right, Amani works in the accounting department. She files a formal complaint because several of her coworkers are making fun of her, the hijab she wears to work, her head covering, and often refer to her as camel jockey or Arab. True or false? The derogatory remarks made by Amani's coworkers are creating a hostile work environment for her. True, right? They are making these comments often. They are based on a protected class. They're unwelcome, okay? Amani finds them offensive. A reasonable person in Amani's shoes would agree. So these are creating a hostile work environment. They are unlawful harassment or discrimination based on Amani's religion, but they could also be creating a hostile work environment for Amani based on her national origin or race, depending on where she's from, because some of these terms are referring to certain parts of the world. So what if instead of Amani's coworkers making the comments, it was a customer, a non-employee coming onto the work site, and that non-employee is making those comments to Amani? What happens then? Okay. Well, the state as an employer has a responsibility to protect its employees from discrimination and harassment from coworkers and from non-employees who come on the work site. That can include employees of other businesses. Okay, so employees of other businesses who come on the work site to make repairs, to make deliveries, to service equipment, all right? Could be visitors to the work site, could be customers or clients that are coming onto the work site. So what do you do as an employee if you have a non-employee third party making comments to you that are derogatory, they're based on protected class, they violate this policy? What do? You need to report it. You need to tell your supervisor that it's happening, okay? There are ways to stop this type of conduct, but it can't be stopped if we don't know about it, okay? So the employer has to be put on notice that it's happening. You need to let them know, and then they can work on stopping it. All right, national origin. Ashari speaks with a thick accent. Her coworkers occasionally ask her to repeat herself so they can understand what she's saying. One day, Howard gets frustrated because he can't understand Ashari, and he makes fun of the way she talks. True or false? There's nothing wrong with Howard's behavior because Ashari is an American and should speak English so that everyone understands her. Who thinks that's true? Who thinks it's false? Okay. Yes, false, right? Because accents are a component of national origin. Okay. Now, in this case, it looks like Howard's conduct was isolated. He just got frustrated because he couldn't understand Ashari and he made fun of her. Doesn't look like it's happening all the time. So Howard's conduct is not rising to the level of unlawful harassment or discrimination, but it does violate the policy. It's inappropriate to make fun of other employees' accents in the workplace. All right, age. Joe is the oldest employee in his division where he's worked for 30 years. His supervisor has prevented Joe from performing the more physical tasks because she's afraid Joe will hurt himself. As a result, Joe's coworkers have taken to calling him Gramps. Joe really doesn't like this and asks them to stop, but they blow him off and they continue using the nickname. True or false? Joe's supervisor is right to protect Joe because he's older, but Joe's coworkers shouldn't call him Gramps. Okay? True, false? Okay, it's a little of both. All right, it's true and it's false. All right, true. Joe's coworkers should not be calling him Gramps. They are calling him a nickname based on his age. Okay, he does not like it. That's not appropriate. But it's false that Joe's supervisor was right to try to protect Joe from hurting himself because of his age. All right, she was assuming because he's older that he might hurt himself. Right? Joe has a job, and he has duties he's required to perform as part of that job. Joe needs to perform those duties just like any other employee in that job. Doesn't matter how old he is. Right? If Joe has a problem, he has some physical condition that would prevent him from being able to perform one or more of the duties, he needs to talk to his supervisor, and they need to see if there's some way they could accommodate him so that he could perform his functions. But it's not appropriate for the supervisor to assume Joe is going to hurt himself because he's older and take duties away from him. That's not appropriate. All right, let's just say, instead of Joe being the oldest worker, okay, he was the youngest employee in the office. His supervisor didn't allow him to perform the more difficult tasks, and his coworkers were referring to him as Barney, as in the purple dinosaur. Does that change your answer? No, it doesn't, okay? It's still inappropriate to call him a nickname based on his age because in Hawaii, employees of all ages are protected. You can't make employment decisions based on age, and it doesn't matter what that age is. You can't treat employees differently because of their age, and it doesn't matter what the age is, okay? So same result with this scenario. Supervisor should not be taking duties away from Joe because he's younger. He's afraid he might hurt himself, and it's inappropriate for his coworkers to call him a nickname based on his age. Okay, physical or mental disabilities. George was born with a clubfoot that makes him walk with a limp. One day at lunch, George walks into the break room as one of his coworkers, Keone, is in the middle of imitating the way George walks while the other coworkers laugh. George complains to his supervisor. True or false? Keone's behavior wasn't discriminatory because he didn't mean to imitate George while George was around. Anybody think it's true? Thinks it's false? Okay, false. And it's false because it doesn't matter what Keone intended, right? It doesn't matter what Keone intended. It doesn't matter if he didn't mean for George to see him imitating him, all right? It only matters what George perceived, and George found the conduct unwelcome. All right, now in this situation, it looks like Keone may have done this one time, all right? So it wouldn't rise to the level of unlawful discrimination or harassment, but it would violate the policy. It's inappropriate to make fun of employees' disabilities. Okay? Now, what if George had not walked into the break room and he didn't see Keone imitating him? Would that make it okay? Okay, good answer. It would not make it okay. Okay? Still inappropriate for Keone to imitate or make fun of George's disability. Doesn't matter if George knows or not. All right. So in Section 1 of your policy, there's a list of reasonable accommodations that employers are required to provide to employees. Okay, the first one is accommodations for physical or mental disabilities. So an employee with a physical or mental disability, and like I explained before, that definition is very broad. It includes most serious medical conditions. Okay, if an employee has a physical or mental disability that is affecting their ability to perform an essential function of their job, okay, so it needs to be an essential function, the employer needs to provide a reasonable accommodation. Okay, so the accommodation needs to be reasonable. It's not always possible to find a reasonable accommodation. Just going to let you know, okay? And just so you know, also, it is the employee's responsibility to make the request for reasonable accommodation. It is not appropriate for the supervisor to assume that an employee has a disability, even if it's obvious. Not appropriate for the employer to assume there's a disability there and to make accommodations for it without the employee asking. Okay? If the employee doesn't ask, they will be treated like everybody else and expected to perform all of the essential functions of their job. If there is some kind of medical condition that is affecting their ability to perform an essential function, they need to let their employer know if they think there's some kind of accommodation that could help. Okay? Religion, we talked about that. Employers are required to provide reasonable accommodations for religious observances, which can include flexible schedules, shift substitutes, okay, modifying workplace practices or policies. Pregnancy-related disability. Employee who is pregnant, becomes disabled because of the pregnancy or after giving birth, is entitled to a reasonable amount of time off work. And expressing milk in the workplace, as of July 1, 2013, employers are required to provide a private area for employees to express milk in the workplace. It does not have to be an office, but it cannot be the bathroom, unless the bathroom has a lounge attached to it that's more private. Okay, so it needs to be an area that is private from coworkers and the public that would allow an employee to express milk in the workplace. And if an employee can express milk to the extent they need to within the breaks that they are allowed, then the employer would need to, oops, sorry, I did not mean to do that. It did it by itself. Then the employer would need to work with that employee to come up with some kind of flex schedule, if possible, to allow the employee to express milk in the workplace and get their 8 hours in. Because again, employee has to work the 8 hours to get paid the 8 hours. And then for victims of domestic or sexual violence, or for employees who have dependents who are victims of domestic or sexual violence, accommodations include changing contact information, screening telephone calls, changing work locations, restructuring job functions, installing locks, or allowing flexible schedules. Okay, so now we're going to go through some examples of inappropriate conduct in the workplace. All right, this is not an all-inclusive list. So if you think of other examples of conduct that might be inappropriate in the workplace, it could be, and just because it's not on this list doesn't mean it's not inappropriate. All right, so let's start with inappropriate verbal conduct in the workplace. Derogatory comments based on gender, race, national origin, religion. All right, we went over scenarios with examples of these type of derogatory comments. Okay, but it can also include the nicknames, stereotypes about different national origins or races. Okay, we know that there are a lot of them, right? And they are used sometimes commonly, and a lot of times people use them in ways that they think is harmless. They don't think that they're not intending it to be derogatory in any way, okay? The problem is that these nicknames or stereotypes can be offensive to people, all right? It could be that these stereotypes or nicknames have been used in the past in a derogatory way, so people are offended when they're used. So be careful when using those types of terms in the workplace. Suggestive or derogatory comments about clothing or personal behavior. So suggestive comments about a woman's clothing could create a hostile work environment based on her gender, okay? Derogatory comments about clothing or personal behavior that is religious in nature, okay, could impact somebody based on their religion. Or derogatory comments about clothing or personal behavior that might be cultural, all right? That could impact somebody based on their race or national origin. Colloquial terms, and by that I mean those terms that become common, they're used commonly, okay? Where they come from, I don't really know, but they become commonplace, all right, in certain demographics, such as hoe, cougar, ratchet, breezy, kitty. And I'll just let you know, I had to tap into a different generation to come up with these. I don't really know what they mean. I never hear these terms, okay? So, but they can be used commonly amongst certain demographics, and they could be offensive to people. I do actually know, I've heard the word hoe, okay? Doesn't refer to somebody's last name. It is a reference to a word that's not so flattering towards women, all right? Now, if that becomes a word that people use commonly, but they don't mean it offensively, it could be taken that way, okay? I might find it offensive if somebody called me that, all right? So colloquial type terms. And that goes for in terms of endearment, like honey, sweetheart, babe, sugar, love, okay? Most people who use these terms mean them with the kindest of intentions. The problem is that they can be offensive to people. Okay, these types of terms historically have been used in ways that are demeaning towards women, so they can be offensive. References to an adult as girl or boy, doll or hunk. Right? So women, you may think that all men would be flattered to be called a hunk. Okay, men, you may think that women are flattered to be called hot, but it is just not necessarily the case. It can be offensive. Racially or sexually charged slurs or jokes. Jokes are a problem, all right? Jokes are always making fun of something. Most of the time, they're making fun of a protected class. Okay, we have all the jokes about different races, the jokes about different national origins, the Polak jokes, jokes about gender, the blonde jokes, jokes about different religions, sexual orientation, you name it. There's just so many of them. It can get out of control, okay? So jokes about protected classes are going to be a problem. They can violate the policy, all right? But I'm going to tell you that lawyer jokes are okay. Lawyers are not a protected class yet, okay? So get out your lawyer joke book, you're good to go. All right, profanity. Profanity is also a problem in the workplace because most profanity is sexually charged. Okay, so it can be sexual in nature, can create hostile work environment based on gender. Okay, so profanity is a problem. Requesting sexual favors in exchange for employment benefits. This is what people think of when they think of sexual harassment traditionally, all right? This is when a supervisor offers a promotion or a pay raise to an employee in exchange for a sexual favor or a date, okay? Or the supervisor threatens with demotion or termination if the employee won't go out with them on a date or provide a sexual favor, right? This is unlawful harassment, okay? Violates the policy. It's inappropriate in the workplace. Tales of one's partner's sexual inadequacies or prowess, all right? That just falls under the category of too much information. Grunts, wolf whistles, catcalls, hoots, lip smacks. Graphic descriptions of pornography, again, TMI. Obscene phone calls, texts, or voicemails. So if an employee is making obscene phone calls based on a protected class, based on race, national origin, gender, okay, that can create a hostile work environment for coworkers. And if they are doing it through their personal cell phones or devices, that can also be creating a hostile work environment. Lies or rumors about a person's personal or sex life. Requests for dates or sexual favors. So we have Tony repeatedly asking Nalani out on dates and she repeatedly telling him no, all right? That can create a hostile work environment. Okay, that can be unlawful harassment. Now, I realize that employees meet at work and sometimes they start dating, okay? And it happens, and I can't do much about it. But I'm just going to tell you that that can come back and create problems in the workplace. Okay, so if the relationship goes bad and the two employees break up, it can come back and create harassment claims in the workplace and other types of claims in the workplace. See it happen quite a bit. All right, so be aware of that. Sexual innuendos or stories. All right, so Joey's story with a sexually explicit line, not appropriate in the workplace. And then we have the words that have double meanings. All right, that could be used in a sexual way. Those can be problematic in the workplace. Comments about a person's body or body parts. All right, then we have inappropriate physical conduct, sexual assault. I hope it goes without saying that you know that sexual assault is not appropriate in the workplace. I almost didn't put this in the presentation because it seemed so obvious, but then I went to a seminar on sexual violence in the workplace and learned that it happens quite a bit in the American workforce. I was quite surprised, okay? And some of the employers where it is happening are well-known national companies, okay? So needless to say, sexual assault is not appropriate in the workplace. It violates the state's policy. It is unlawful harassment, and it violates many other laws, mostly criminal. Non-consensual kissing, hugging, patting, stroking, grabbing. That gets us back to the touching, okay? Touching of certain areas of the body are going to be severe in and of themselves. They will be unlawful harassment. Leaning over or invading a person's space. So if you lean over your coworker's shoulder to see their computer screen, you could be too close for comfort. You could be causing an uncomfortable situation for that coworker. If you are talking to somebody and they are backing up, you are probably too close. Okay? Pay attention to people's body language. It can tell you quite a bit. People have circles, and some of them are bigger than others. Inappropriately touching a person or person's clothing. Accidentally brushing sexual parts of the body. So instead of Joey grabbing Jessica's breast, he accidentally brushed his hand against her breast. Okay, same problem. Uninvited neck or shoulder massages. Deliberately touching in a sexual nature, brushing up against, pinching, patting. Okay, back to the touching. And then we have stalking. Okay, so if an employee is stalking a coworker because of a sexual attraction, all right, that can create a hostile work environment. That can be done through notes, emails, personal cell phones, or devices. All right. And then we have our lovely lady with the lei. Okay, what about showing aloha in the workplace? Is that a problem? Because what do? We give somebody a lei, we give them a kiss on the cheek, we give them a hug. Okay, and there are different schools of thought on this. Some attorneys will tell you, don't do it. Just say no, don't do it. Too much kissing, too much hugging in the workplace. Okay. Another school of thought, be aware that not everybody is comfortable with this custom. Okay. We all come from different backgrounds, and a lot of people's backgrounds may not include touching or hugging. Okay, so just be aware of that. I have run into people during this training who are part Hawaiian, born and raised in Hawaii, and they're not comfortable with this custom. So just because you're comfortable with it doesn't necessarily mean everybody else is comfortable with it. All right, inappropriate nonverbal conduct in the workplace. Staring, making facial expressions of a sexual nature, winking, licking lips. Making derogatory gestures of a sexual nature, usually involving hand motions, giving sexually suggestive looks, looking someone up and down. Okay, then we have displays. Displays of demeaning, insulting, or sexually suggestive objects, pictures, or photographs. Okay, we've already talked about nudity in the workplace. Okay, not appropriate. Never going to be appropriate. We've talked about texts, emails, including the use of personal cell phones or devices. Okay, internet materials. I think you all know that it is not appropriate to view pornography on your work computer. If you don't know, I'm going to tell you it's not appropriate to view pornography on your work computer. Okay, but it's also not appropriate to view pornography on your personal cell phone or device while you're at work. Right? That goes for video clips. So say a friend sends you a video clip of this comedian who's really funny, but he loves to go off on different races. Okay, that's not going to be appropriate to watch while you're in the workplace. Or somebody sends you a video clip of the newest music video that has explicit lyrics or sexually explicit lyrics or nudity, okay? Not appropriate to watch while you are at work. All right, that gets us to retaliation. Okay, retaliation is prohibited by law and by the policy. It's defined in Section 5B of the policy. And it is an adverse employment action or threat of adverse employment action that is in response to or in attempt to prevent a person from making a complaint of discrimination, okay, or in response to or in attempt to prevent a person from participating in an investigation of a complaint of discrimination or harassment, or in response to or in an attempt to prevent somebody from making a request for reasonable accommodation. All right, so adverse employment actions. What are they? Firing, failing to promote or demoting, disciplining, reassigning somebody to duties that are significantly different, okay, or changing benefits in a significant way. Those are adverse employment actions. Okay. Now, the adverse employment action has to have a causal connection to the protected activity. Protected activity is making a complaint of discrimination or harassment or participating in an investigation. So say you as an employee witnessed other employees who were engaging in discriminatory conduct. So the employer is now asking you what you saw, and you're telling the employee that's protected conduct. All right? Making a request for reasonable accommodation is protected conduct. All right, so there has to be a causal connection. So as an example, let's say we have Maria and Randy. Randy is Maria's supervisor, and he is telling the racially derogatory jokes during team meetings. Okay? Maria complains. 3 days later, Maria is written up for performance. Okay, what does that look like? Right, retaliation, okay? Looks like we've got an adverse employment action that is in response to a complaint of discrimination, okay? But let's say that Maria had been having performance problems. She'd had performance problems for months. Her supervisors, including Randy, had been working with her to improve her performance, so she was in that performance track, okay? That's the track where people can be written up if they do not improve their performance. Maria makes the complaint. 3 days later, Randy writes her up for performance that's related to her performance problems. Okay? Do you see a difference in that scenario? Okay? There is a difference. The write-up is related to her performance problems. It is not necessarily in response to her complaint of discrimination. Okay, so there's no causal connection between the adverse employment action and the complaint. All right. So retaliation does not include petty slights, annoyances, snubbing of a colleague, okay, negative comments about work performance, or requests to improve productivity if they are justified. Okay, so this scenario is based on a United States Supreme Court case. Myron, a laborer, made an internal complaint against his supervisor for race discrimination. 2 weeks later, his supervisor reassigned Myron from operating the forklift, the most desirable assignment, to standard labor tasks, which was not the most desirable work assignment. His pay and working hours did not change. True or false? Myron's supervisor did not retaliate because Myron's pay and working hours didn't change. Who thinks it's true? Who thinks it's false? Okay, you're right. It's false. Up until this case, however, the answer wasn't necessarily false. Okay, there were courts that were finding no retaliation if pay and working hours didn't change. They were saying a change in duties was not an adverse employment action. But the Supreme Court looked at these facts and they said, okay, Myron makes a complaint, discrimination, and then he's moved off the most desirable job assignment to the worst job assignment. Okay, what does that communicate to Myron? Okay, it's communicating to him, don't complain, don't complain. Okay, and what does it communicate to Myron's coworkers? Same thing, right? Nobody wants to get changed off the best job assignment. So the Supreme Court said that retaliation can occur even though pay and working hours don't change, if there's a significant change in job duties. All right, so this is a practice, all right? Let's just assume we have an employee who has made a complaint of discrimination or harassment, okay? I'm going to read you some scenarios. I want you to tell me whether you think it's a petty slight, retaliation, or whether it depends, all right? The supervisor refuses to acknowledge the employee when they pass in the hall. Who thinks that's a petty slight? Okay. Who thinks it's retaliation? Who thinks it depends? Okay. Well, when the supervisor refuses to acknowledge an employee, they are not taking any adverse employment action. Okay, they're not terminating, they're not disciplining, they're not changing job duties, they're not changing benefits, they're not changing pay or working hours. Okay, so it really is a petty slight. All right, the supervisor denies the employee's vacation request to go to a relative's wedding. Who thinks that's a petty slight? Who thinks it's retaliation? Who thinks it depends? Okay. It does depend because there could be a collective bargaining agreement in place or a policy in place that dictates how vacation is to be assigned. All right, so if the supervisor was just following the collective bargaining agreement or the policy in denying the employee's vacation request, it wouldn't be retaliation. Okay, the supervisor had a legitimate business reason to deny the vacation request. But if there was no collective bargaining agreement in place, there was no policy, and the supervisor knew this employee was going to a family wedding, okay, knew it was an important vacation request, and denied it, it looks like retaliation, right? Because there's no reason to deny it, and it's affecting his benefits. The employer assigns the employee to a less desirable work cubicle. Who thinks that's a petty slight? Who thinks it's retaliation? Who thinks it depends? Okay. Well, I've been told by different supervisors that there are work settings where workstations are rotated or changed on a regular basis. It's not unusual to change employees from one workstation to another. So if that was the type of work environment this employee worked in, it wouldn't be retaliation because it would be normal, okay? Or let's just say the employee moved from one cubicle to another, or was moved from one cubicle to another. Everybody else looking at the two cubicles couldn't see anything different about them. Okay, but the employee felt like the new cubicle was less desirable. He's the only one that could see any difference. That wouldn't be retaliation, okay, because a reasonable person couldn't see a difference. It's objectively not different. But if the employee was moved to a cubicle that was isolated from employees or coworkers that he needed to work with to get his job done, or isolated from equipment that he might need to get his job done, a phone, computer, fax, copier, that could be retaliation. It's affecting his ability to perform his duties. Okay, the employee is given a written warning for work performance 3 days after he filed a complaint of discrimination. Who thinks that's a petty slight? Who thinks it's retaliation? Who thinks it depends? Okay. All right, it does depend. All right, let's just say the employee has no performance problems, no documentation of any performance problems. Okay, nothing in his personnel file to indicate there's ever been a performance problem for this employee. Okay, he makes a complaint, 3 days later he's written up for performance. All right, that looks like retaliation, right? There is no reason to give him a performance write-up. Okay, so the only reason we could come up with is it has to be in response to him making a complaint. But if that employee had performance problems, a history of them, they were documented, okay, the write-up was related to those performance problems, okay, then that wouldn't be retaliation. The employer has a legitimate reason to write the employee up for performance. Does that make sense? Okay. Now, if the employee had performance problems that were documented, but the write-up was related to different performance problems, okay, that could be retaliation, okay, because those performance issues hadn't been dealt with. We all know there's a process that has to go through, okay. If the process isn't gone through and they're written up, it could be retaliation. Okay, the supervisor excludes the employee from regular weekly meetings with the employee's division. Who thinks that's a petty slight? Who thinks it's retaliation? Who thinks it depends? Okay. All right, if an employee or if the regular weekly meetings were to discuss work, okay, so every week they get together, they discuss what work needs to be done that week, how they're going to get it done, and the employee is excluded from that, well, the employee is now excluded from information that he needs to get his job done, right? Okay, so that looks like retaliation. Okay, but if the employee could have a very important project he's working on, it's time sensitive, there's a deadline, the supervisor is aware of that, the supervisor says, you know, don't come to the weekly meetings, you need to focus on this project, spend all your time focusing on it, right? Then it might not be retaliation. But do you kind of see the trend? The supervisor has to have a legitimate business reason to take any kind of adverse employment action. Okay, if there's not one, it makes it very hard to explain how it isn't retaliation. Okay? All right, and then the supervisor does not attend an employee's birthday celebration in the break room, even though he was in the office. Who thinks that's a petty slight? Who thinks it's retaliation? Who thinks it depends? Okay. Again, not attending an employee's birthday celebration is not an adverse employment action. Okay? No change in benefits, no change in pay or working hours, no change in duties. Okay? So, petty slight. All right. Have a little scenario I'm going to read. I want you to tell me, mark, check, circle, any conduct that you think might violate the policy. All right, are you ready? One day at work, Lori is upset about personal issues at home and starts crying in her cubicle. David, who sits next to Lori, sees her and gives her a big hug to make her feel better. Martin walks by and sees them. He takes a picture of them and emails it to all of the employees in the division with the subject line, "Look who's hooking up." Afterwards, while Martin is talking to another coworker, Melissa, about a project, he leans over Melissa's shoulder in order to see her computer screen. Melissa pushes Martin away and in doing so notices a tattoo on the inside of Martin's upper arm that has a racially offensive connotation. Melissa asks Martin why he has such a vulgar tattoo, and Martin explains that he got it when he was young and stupid. Meanwhile, Lori, who has now heard about the email that Martin sent to all of her coworkers, approaches Martin and tells him to stop spreading rumors about her. Martin tells Lori, "Oh, calm down. I was just having some fun. You're just overly sensitive because of that church you go to." Lori says she's going to talk to the supervisor, about all this, sorry. And Martin, who has already been given a verbal warning for office gossip, blocks Lori on her way and says, "Lori, I wouldn't do that if I were you." All right. Did anybody see anything that might violate the policy? Okay, good, because dang it, this is really acting up. Anyway, if you didn't, I was just going to tell you to come talk to me about a remedial course on EEO. Okay, so what about David's big hug? Could that be a problem? It could be, right? It could be because Lori might not be comfortable with big hugs. She might not be comfortable with big hugs from men. All right. Whoa, sorry. This is cheating. Emails. What about the emails with the tagline? Look who's hooking up. Yeah, could be a problem. He is spreading rumors about his coworker's personal and or sex life. Okay, what about, sorry. Dang. Okay, what about Martin leaning over Melissa's shoulders? Yep, could be too close for comfort. In this case, it looked like he did because Melissa pushed him away. Okay, let's see if this will do it when I click. All right, and then we have the vulgar tattoo. Could that be a problem? Sorry. Okay, could be a problem, right? It had a racially offensive connotation. Melissa saw it. Now, it sounds like it was on his upper inside of his arm and may not be visible with short shirt sleeves. So that would be something that would need to be considered in looking into this situation. Okay, and then we have Martin's comment about Lori's church. Plug in any church, right? He's making fun or making comments derogatory about her religion or her church. And then Martin blocking Lori and threatening her. Okay, what is Martin doing other than maybe violating the workplace violence policy? Okay, that is a form of retaliation. Now, Martin is not Lori's supervisor. He cannot take an adverse employment action against Lori. Okay, he can't discipline her, he can't fire her, but what he's doing is he's trying to keep Lori from making a complaint. He knows he's going to get in trouble, and he's trying to keep her from complaining. That's a form of retaliation. Okay, so that violates this policy. It may violate other policies. All right? So, if you had to spend the day with Martin, okay, what do you do? Right? Well, there are reporting requirements in Section 6A, okay, for employees. Employees need to report conduct that they see, they witness with their eyes, or that they are subjected to that is unlawful harassment or discrimination, okay, or that violates this policy. Or if it's retaliation, okay, the employee needs to report it. It's very important that the employees report, okay? If an employee doesn't report conduct that might violate this policy, the employer will never know about it. They can't stop it, right? Okay? The whole purpose of the policy is to stop discrimination and harassment in the workplace, right? It's to stop it. And there's no way to stop it unless we know about it. Okay? So, employees have to help by reporting conduct that they think violates the policy. Now, who do you report to? The policy has different individuals that you can go to. Okay? You can go to any manager. You can go to the EEO or Civil Rights Compliance Officer for your department if you have one. Okay? The 4 larger departments for this executive branch of the state have Civil Rights Compliance Offices. That's the Department of Transportation, Public Safety, Department of Health, Department of Human Services. The smaller departments have Departmental Personnel Officers, DPOs. Okay, that is a person you can go to. Sometimes the DPO has designated another person to deal with EEO matters. Okay, that would be the person you should talk to. If you're not sure, go back to your department and find out, because you need to know. You need to know who you should go to if you feel like this policy is being violated, you see conduct happening, or you are subjected to conduct that you think violates this policy. All right, now, when an employee reports conduct that may violate the policy, an employer is legally obligated to act. And what that means is the employer has to find out whether the conduct is occurring. And if it is, they have to stop it. Okay? Legally obligated to stop it. Okay? Because remember I said employers can get in trouble if they allow discrimination and harassment in the workplace. Okay? So because of that, the employer cannot keep complaints 100% confidential. Because if they do, they can't act, they can't make sure it stops. They have to talk to people. They have to talk to the complainant, talk to the person making the complaint, find out what happened. They have to talk to the person who was accused of the conduct to find out what their side of the story is, and then you talk to any witnesses that might have seen the conduct to determine whether it happened or not. Okay? So, can't be held 100% confidential. That's dealt with in Section 6B of the policy. But that said, whoever you report to doesn't have the right to tell everybody they know, to tell all of your coworkers. If they have nothing to do with this, they don't need to know about your complaint. Okay? And this goes even if you make a complaint that's verbal. Okay? There is a complaint form attached to policy. So if you go to the website, there's a complaint form attached to that policy that you could fill out, and that's great. But if you make a verbal complaint, you report conduct verbally, the employer has the same obligation, the same duty to act. Okay? As soon as they know about conduct or might know about conduct, they have an obligation to act. All right, and then employees do not have to confront the offender. So the person engaging in the conduct that may be discriminatory or harassing, the employer does not have to confront them. So in Jessica and Joey's scenario, Jessica felt comfortable telling Joey she thought his joke was offensive. Okay? So she told him, and that was fine. And it stopped the conduct. So a lot of times that's a very effective way to handle it. But if Jessica had not been comfortable telling Joey, that would have been fine too. She could have gone to her DPO, gone to the Civil Rights Office. She could have come to my office and made the complaint. Okay, so employees can come to the EEO office for the executive branch, and if you do, what I'm going to do, what my office will do, is make sure that the appropriate person in your department knows and can deal with it, and then monitor it, make sure it's get handled properly. All right, so what's the most important reason to report conduct that you witness or are subjected to that you believe violates this policy? 1, to make your coworkers like you more. 2, to make the department aware of problems in the workplace. Or 3, to get your people you don't like in trouble. All right, who thinks it's 1? Who thinks it's 2? Okay, and anybody who thinks it's 3, come talk to me after the class. Because it is 2. The whole point of this is to make sure, make the department aware of conduct that's happening so that it can be stopped. All right, if it's inappropriate conduct under the policy, it needs to be stopped. All right, so more responsibilities for you as employees. Section 6C3, you have the responsibility to conduct yourselves appropriately in the workplace. Okay, so all of those examples of inappropriate conduct, don't do it. Okay, just say no. All right, also, you can conduct yourselves appropriately by respecting the people around you. Okay, respecting your coworkers, respecting your supervisors, treating them with respect. Okay, think before acting, think before speaking. Think to yourself, could somebody interpret this as offensive. Okay, if I say this nickname about this stereotype about this race, could somebody find it offensive? If I give a big hug to this person, could they find it offensive? Think about it before you do it. Imagine how other people might be feeling. Okay, people come from different backgrounds. They are going through different lives than you. They are dealing with different issues. They may be feeling differently about things than you are. So think about that. Be sensitive to diverse perspectives. Okay, we work in a very diverse workforce. People come from different backgrounds, and they have different perspectives on life, different perspectives on work, a lot of different things, okay? Be aware of that. Be sensitive to that. Exercise common courtesy, okay? Treat others the way you would like to be treated. All right, think twice about making jokes, okay? Because like I said, jokes are problems. They're always making fun of something, okay? So when you're in the workplace, and you are talking to your coworkers and you're considering making fun of this employee down the way that just has very funny mannerisms or has a religion that's weird or whatever reason, okay? Think about these things. Ask yourself this. How would I feel if I were in the position of the victim? How would I feel if I were in the position of the person that I'm about to make fun of or I think I'm going to make fun of, okay? Would I want my spouse, parent, child, sibling, or friend to be treated this way? Would I want somebody making fun of my spouse or my child the way I'm about to make fun of somebody? Okay. Would I like my behavior published in the newspaper? How do you think I found out about the sexting lawsuit? Okay. It was on the news. So if you engage in conduct that is discriminatory or harassing, you could end up in the newspaper or on the news. And then ask yourself, could someone misinterpret my behavior as intentionally harmful or harassing? All right? Could David's well-intentioned hug be interpreted as harmful or harassing? Okay, maybe. All right, so think about these things in the workplace. And with that, we are done, and we have about 10 minutes to take questions. All right, any questions? Yes.
I just had a question about the Robert and Roberta, because the legal documents, though, would still say Robert in the workplace unless he gets a legal name change to reflect this.
Correct.
Gender?
Not everybody that wants to be referred to as a different name have a legal name change. Their legal documents may still say that their name is Robert, okay? But think about it this way. You know, when somebody's name is William and they ask to be called Chip, we call him Chip, right? Okay? So, and some people really don't like their given name. They want to be called a different name, okay? So we just do it out of respect. They ask us to call them that name, we call them that name, okay? Now, the legal way they deal with the legal documents would be the same as any other legal documents, okay? Yes? Oh, okay. Is there a site? Somebody in a site? Okay. If you have a question, just click your microphone.
I had a question.
Okay.
What if your job requires you to do something that's against your religion? For example, a creationist is required to teach evolution.
Okay. Well, luckily we're not dealing with the Department of Education. They have a whole bunch of different areas that they deal with. Okay. But I'm not really sure of an example within the executive branch where that would occur. But if it does occur, you just need to go and talk to the Civil Rights Compliance Office, your supervisor. You can come to my office and we'll just deal with it as best we can, okay? Because that would be where a reasonable accommodation may be able to be made. Any other questions? Okay, now, you have my contact information. If you do email me, would you please identify who you are and what department you work with? It makes it really hard for me to respond if I don't know who you are. So that's usually my first question is, can you tell me who you are? Okay, so if you do email me, please do that. And feel free to email or call, okay? Thank you very much.